Hey everybody, how's it going? And welcome back to Copper Jacket TV. So if you guys live in California or any other state that has a similar handgun roster, you're going to want to watch this video. Today we're going to be talking about a federal judge out of the state of California that has ruled in favor of the Second Amendment. Now this is a follow-up video to yesterday's video as well as a correction to some mistakes that I made in that video. So let's talk about what's going on. Okay, so yesterday I made a video talking about how Californians might finally be seeing some relief when it comes to the roster. The case is Renna V. Bonta, which challenges the UHA or the roster, and it has a hearing scheduled for February 10th of 2023 at 1:30 p.m. Now, this hearing is for a possible injunction, and if an injunction is granted in this, that means that California wouldn't be able to enforce the UHA anymore, and you can see that that would be absolutely major in the state of California. Finally, putting a hold or at least a temporary freeze on one of the most unconstitutional, laws or regulations in that state. So that was pretty big. Now, at the time, I said that I didn't really know much about the judge. I just finished reading a bunch of documents, brushing up on Renna V. Bonta, the latest court filings and stuff, and I hadn't got into the judge that was going to be hearing this potential injunction. So I mentioned that it was a woman, Dana Sabraw. And I apparently was wrong. After I got an email last night from somebody who knows a lot more than I do, Dana Sabraw is actually a man. And not only that, it's a George Bush appointee who has significant pro-2A rulings in the past that we can specifically look at. So I decided to really dive in and find out who this person is that's going to be hearing this potential injunction. And I got to tell you this. It looks really, really good. If you guys were excited for a potential injunction in the past, I'd be twice as excited now today. So let me tell you a little bit about this judge because it very much matters. Now, like I said before, after that email last night, I decided to do some more research about Judge Sabraw, and I found something that was extremely eye-opening, and I don't know how I missed the name because I've been following this case very closely, but as a matter of fact, Judge Sabraw has already issued a ruling in this case, this specific case, Renna V. Bonta, once in the past, and it was a pro-Second Amendment ruling. So this is something that he's already been involved with, and as a matter of fact, already said that California's scheme is basically unconstitutional. So I want to put an article up on the screen here so you guys can kind of read it along with me, and it'll tell you a little bit more about his ruling and who he is, and that should give you some insight as to whether or not we could potentially see an injunction come this February. So what you're seeing on the screen right now is directly from the 2AF website, and I want to go ahead and read this, even though I know you can read it for yourself, but I'll just try and make things easier. So I'm just going to summarize the first paragraph, which basically just says that the Second Amendment Foundation is applauding a federal judge that said that a provision in the roster, which says that if you add one new, you have to remove three that are already on the list, is a violation of the Second Amendment. And so they're applauding that. The second paragraph, the ruling by the U.S. District Chief Judge Dana Sabraw is a slap at California's law, which took effect January 1st of this year. The law was brought by the SAF, Second Amendment Foundation, the San Diego County Gun Owners PAC, FPC, and a private citizen, which is basically Renna, for who the case is actually named. Now, the next paragraph, in his 15-page ruling, Judge Sabraw, a George Bush appointee, ruled that the plaintiffs have sufficiently pled that the UHA, the Unsafe Handgun Act, substantially impacts their Second Amendment rights and thus burdens conduct protected by the Second Amendment. So again, you can see right there that this judge has already said that the roster is unconstitutional. It violates the Second Amendment. Now, this next paragraph is very eye-opening. While we're talking specifically about the provision that is the 3-to-1, basically one new added to the roster means three taken off, it still gives you some insight as to how the judge is thinking about the roster, and clearly he can see through California's scheme here and can see that eventually the roster is going to be a complete ban. It's just going to limit everything as things start to fall off of the roster because under the rules and regulations of the roster, there's nothing really new that can be added. But let me go ahead and read you this here. So he also noted, and that's the judge, the plaintiffs, which is Renna, alleges that the UHA roster imposes a significant burden on their Second Amendment rights. Specifically, the complaint alleges that the number of handguns available for purchase on the roster continues to decline and ultimately will shrink into oblivion as handguns are removed from the roster, including by AB 2847, the 3-for-1 provision. Taking plaintiffs' allegations as true, this limits the ability of law-abiding citizens to acquire firearms, which is critical to ensuring the Second Amendment right to keep arms. Now, if you paid attention there, you'll notice that at the end of his statement, the judge said to keep, not the full phrase to keep and bear arms, but to keep arms, because he's specifying that specific part of the phrase. To keep and to bear are two totally different things. In order to keep, you have to be able to acquire. To keep, it's to have, right? And to bear is something that's separate. But this list does not allow people to acquire or to keep. It eventually is going to shrink into nothingness. So right there, he's sort of acknowledging the fact that it does violate part of the Second Amendment. Now, I would argue that obviously if you're not able to keep, you're not going to be able to bear either. And so those two kind of work hand in hand. But I think that him kind of pointing out that fact that it kind of goes after keep in the Second Amendment is a clear violation. I think that definitely gives us an indicator as to where his mind, his frame of mind is in this particular suit. Now, I'm not a lawyer. I'm just somebody who's been doing this for, the past 10 or 11 years now. And I try and dive deep into these things. Obviously, I missed the ball when it came to who the judge was for the February 10th hearing. But I try and give the information back to you guys in layman terms because that's how I understand things too. So I try and make it relatable so people can kind of understand what's going on here. And to me, again, being the layman, right? To me, it seems like all good indicators that, again, the judge sees the unconstitutionality in the roster, and we could be seeing an injunction here, which would be fantastic. I mean, that would be huge news, some of the biggest news that we've seen so far in the state of California. Obviously, there's Duncan, there's the Miller case. There's a lot of really exciting things that are happening in California right now that, if hold up, could have major effects on the rest of the country as well. So, between Renna, Duncan, and Miller, I mean, to me, those are the three most exciting ones that we see right now. And hopefully we see some positive results, but this should at least give you some hope. It's good news instead of, all the bad news that's been happening lately. And I hope that, kind of gives you guys a little bit of something to look forward to. So we'll see what happens. And, when the hearing is set for February 10th, I'm going to see if I can get as much information about that hearing as I can. And then, when the judge actually does come out with his order, his ruling in that, then I will bring you guys the details. So I want to thank you all very much for watching. I really do appreciate it. And I thank you again for that email last night for correcting me. I don't mind being corrected. I'd rather be corrected than wrong. So thank you all again very much. Have a great day.